let's get started. Good morning, everyone. Thank you so much for coming, for joining us today. So my name is Yan Yuemin. I am an assistant professor at Chinese University of Hong Kong, Faculty of Law. So I'm very pleased and to introduce our speaker, Dr. Eken. So Dr. Eken is a tenured assistant professor at Durham Law School, Durham University. He's also one of our very proud CUHK Law alumni. So we are very, very pleased and happy to welcome him back. So today, Dr. Eken is going to present his new book, congratulations, which is actually finished at CUHK Law. Dr. Eken is a triple qualified lawyer as well as a fellow of the Chartered Institute of Arbitrators. He is qualified as an attorney in California and Turkey and a solicitor in England and Wales. So he's on the panel of arbitrators at London Court of International Arbitration, the International Chamber of Commerce, and Dubai International Arbitration Center, Asian International Arbitration Center, and several other international arbitration centers. So I'm sure you will find many more information about today's speaker online. So without further ado, I'm going to invite Dr. Eken to do the presentation, and he will be speaking for around 40 minutes, and then we reserve around 10 minutes for Q&A.
Yuming, thank you very much. First of all, it is really great pleasure to be back at CUHK Law. As Yuming said, that I spent 4 years in this great city and in this great campus. So I wrote majority of my PhD thesis in this campus because 1 year I was at Stanford as a visiting scholar. 2 months I was at Max Planck Institute. And the editing process of this book completed when I was at Durham University in the UK. So it's a long process, but the majority of the work, the main work, the substance was written at the CUHK Law. So it is great to present this book at my home institution in this sense. So I have 40 minutes. I will not try to exceed my time so we can have more time for the discussion at the end. But I will also thank all of you coming and listening my talk. I hope I will not disappoint you, as Yuming said, and you will learn some important information today. So the title of my book is Rethinking Third-Party Funding in Investment Arbitration Towards a New Procedural and Ethical Paradigm. I choose this title first. I should start with the title because third-party funding is impacting the practice of international arbitration in both commercial and investment arbitration in many jurisdictions. There are now recent rules in Hong Kong, in Singapore. There is a recent Supreme Court decision in England, and there will be probably some rules. Many jurisdictions are regulating third-party funding in some forms, and that's why it is impacting the procedure and ethics of the arbitration practice. So the presentation structure today will be following the book structure as well. My book, as you can see here, I brought one copy to give the dean of the law school, Chao Shi. So unfortunately, no more copies, but if you have one, I'm happy to sign for you. But this is how the book looks like. So I will try to explain why I started looking at this topic, what are my research questions and the chapter summaries, and this will be the presentation structure. So the background of the book, I started thinking about this subject when I was in London, actually finishing my master's degree, because this was a very hot topic 10 years ago, and it is still a very hot topic. And people, academics, practitioners were always interested in third-party funding because somehow they were involved, either in academic work or in their practice. Their clients needed money and they needed to develop relations with the third-party funding and funders. And that's why how I heard about this topic, and I also grew some interest. So third-party funding role is important because arbitration, as we know, is expensive. It is not a cheap process. It requires a considerable amount of money, time, effort to bring an arbitration case. And sometimes parties might not have enough capital to bring this case, or even if they have enough capital, they might not always want to take the risk of arbitration, and they want to transfer this risk. So these are the two major reasons why this area is developing and growing constantly. So this book tries to give a holistic approach of this third-party funding practice. What are the procedural issues that it raises in the process, and some of the ethical considerations. So I will try to highlight some important discussions in this short time today, but the more you will find in the book. So one important aspect I really gained a lot from writing this book. I interacted with many funders in 4 years' time, and I interviewed nearly 30 funders, and I asked them a set of questions, and I will share some of the insights from those interviews as well. So my main research question in this book was, is third-party funding distorting the investor-state dispute settlement regime? And what rules would help guide third-party funders in investment arbitration to avoid distorting the system? That was my main ideas and questions in mind writing the book, and I will answer at the end of the book. So the book chapters, I have 5 chapters, 1 conclusion and 1 appendix, the best practice guideline for funders. So in chapter, the titles you can see, I will talk each chapter briefly. So chapter 1 is about this new phenomenon, how third-party funding has developed, a brief history about the third-party funding, and the literature review, what works have been done on this subject, my methodology in the book, and scope of the book. So I need to determine the scope of this book at the beginning to not to disappoint otherwise, because third-party funding is a big subject in commercial arbitration, in litigation, in investment arbitration, in different platforms, in mediation as well, in other alternative dispute resolution mechanisms. My book covers only in investment arbitration aspect. But in the chapter 1, of course, naturally, I talked a little bit about how this practice has developed over time. And I will mention a few important common law principles and a little bit background for you as well. So hopefully, if you didn't know this, you will learn today. There are 2 important common law principles called champerty and maintenance. So these were the traditional barriers for this area to develop further, because champerty and maintenance basically prevents any third parties to involve with the litigation or arbitration process, to protect the rule of law and to protect the objectivity and impartiality of the judges. And I really enjoy one of the quotation from one of the English scholars, jurists from the 18th century. Jeremy Bentham said that in his book, if a baron in the medieval ages in England enters to the doors of the courtroom and sits behind one of the parties, litigants, and then with his all the gorgeous clothes and soldiers and swords entering and supporting this one particular party, the judge would be scared to order anything against that party supported by such influential people. But in the 18th century, when Jeremy Bentham wrote his book, he said that now none of the judges in England would care 100 swords of any lords and barons, even in the 18th century. So that shows that how the rule of law have developed in the world, and how much courts becoming objective and strong in that sense. So now today, of course, 21st century is a different, interesting area as well, and we see that there are also always the rule of law discussions, the problems, issues in many jurisdictions, but a majority, if we compare with 1,000 years ago, we have a good system operational in the world with the strong rule of law, strong principles, and that's how these common law principles, champerty and maintenance, lost their importance over time. And in England in 1967, they were abolished and they were no longer a crime. They are still sometimes affecting as the tort in the civil law aspect, but they are no longer crimes. And the similar trends in other common law jurisdiction in Australia, in Hong Kong, Singapore, we see that these third-party funding legislations recently, they are also abolishing common law principles for the arbitration proceedings. So not every jurisdiction allows third-party funding in their courts, but in arbitration, we see that it is commonly used. This was the brief history and how champerty and maintenance are important in third-party funding, and that's how third-party funding could be developed over time in this area. And in investment arbitration, if I go into that history, the first funded case was 2006 Argentina case. And we have very little 20 years history of third-party funding in investment arbitration. But this might be a little bit longer than that. This is the first publicly known case funded by funders. So this is important aspect because we don't know whether there was third-party funding or supporting any cases early 2000s or before, but even investment arbitration as a system is booming in the last few decades only. So it's a new area of law, and third-party funding is affecting this new area of law as well. So this was the history aspect. I think that I spent enough time for the history part. Now the chapter 2 was about the definition, history, and basic mechanism of third-party funding. So definition is important because we need to define what we are talking about. So third-party funding, what is third-party funding? This depends on the legislation defining third-party funding, but interestingly, we don't have a legislation defining third-party funding in investment arbitration. So what third-party funding according to you can be different than according to another arbitrator. So this is important to define that. So when I started writing my thesis, one of the important works on this subject was the Queen Mary Eken report. And they defined third-party funding in by taking into some considerations. How I define third-party funding is that a traditional, a more default mechanism actually, a professional third-party funder investing in a case, covering the cost in return for an exchanged agreed return from the award, and the goal is profit-based practice. So it is a pure business. So if you have a professional funder investing in the cases, and if the case is successful, they get a share from this award. This is the third-party funding I focused in my book. However, I will give you a few other examples how you can see that there might be other ways of funding cases. There are sometimes pro bono funding. For example, very famous case, Melinda Gates, Bill Gates Foundation basically funded Uruguay with the cases by the Philip Morris tobacco company, because they supported tobacco-free kids around the world, and they wanted to protect the kids' health rights, and that's why they didn't want the tobacco company win a case against Uruguay, and they give the money without any profit or without any expectation. So that was the pro bono funding. It's a very positive case for third-party funding because they don't profit, but they do this for good causes, good deeds for the kids, basically, in that country. I don't want to go into too much details. Basically, you know that the packaging requirements of every cigarette company now, they show how risky it is in their packages. So it started there, and of course, tobacco industry challenged this. The case was about that, but importantly, a foundation funded the state against a big multinational conglomerate company. So this is important because generally we see that traditional professional third-party funders are funding the claimants more commonly. So that was a pro bono case funding the state. It was interesting. Another type of funding we see sometimes in investment arbitration cases, the banks together create a consortium, and they basically fund the claimants to bring a claim, but they are not also professional funders. They are just normal banks, but they do this because they think there is a good case, and they of course draft an agreement between the claimants. It's kind of generally a group of companies, a group of banks coming together, and it's generally a class action, 10,000, 50,000 shareholders, bondholders suing the states. We see this kind of practices as well. But again, these are the different forms of third-party funding than the traditional funders. So These are the general, chapter 2 is talking about how funding can be defined, what are the basic mechanisms, how it works, what the funders are looking at before they accept a case, and how their share is determined. This chapter is covering these aspects. So I will go a little bit more slides explaining these important aspects of third-party funding, but hopefully, when we have time, if you have any questions, we can go into details in those areas. So these are the book I reported to you earlier, Jeremy Bentham, Defense of Usury, and here you can see that as well. So now let's try to set the background a little bit further. I can see my students joined as well from Durham. Welcome. And so why third-party funding is important? So if we talk about this as well. This is a multi-billion-dollar market in the world now, and this market is growing. The reason we gave 2 reasons, because the parties need this money. Funders do not go out and look for the cases. They do, of course, business development to a certain extent, but generally the law firms, the clients themselves are bringing the cases because they need money. And since I'm working on this subject, I received a lot of emails, phone calls every other month from a potential party in a case, whether if I can help them to find a funder because they have a big case but they don't have money. So there is a need in the market, even though I'm full-time academic, but I receive this kind of inquiries. If I start a funding company, of course, there will be more inquiries about that. So there is a need in the market. But it is not always feasible to fund a case because there are different criteria, as I will explain later. So, and another important thing, since my students, a lot of students I can see in the room as well, or other professionals, this is an alternative career. So this is why also this subject is important, because many people actually working in the funders are lawyers. They use their legal knowledge, legal expertise to do business. It is not a legal practice, but they are using their legal practical experience to make money. It's a business based on the legal experience and legal knowledge. So it creates an important career path for our students, as well as people who want to change their career and try something else. As I said, that I met many different funders. Majority are lawyers, but I met a very nice funder in Paris, actually. He was an investment banker, and he said that after 40, he wanted to change a career and show an example to his kids. And that's why he started this funding business, and it is going well as well. So it is an alternative career path for many people. So the basic mechanism of third-party funding, how it works, it is an agreement. Based on at the essence, it is an agreement. So you have a third-party funding agreement between the funder and the funded party. The lawyers are not party to this agreement. But of course, in both sides, you will see that the lawyers might advise their clients, and the client can be funder. And there's an additional alternative career there as well. Some lawyers are now offering funding consultancy, and they advise only third-party funding agreements, either for the funded party who are seeking a funder, or a funder how and what they need to be careful when they are drafting these agreements. And you can negotiate these terms depending on your strength in this transaction. So this funding agreement can be very detailed, but generally what you want to see in this funding agreement, how much capital will be committed to the case, and what reporting duties you will have to the funder throughout the case. The decisions will belong to the party or the funder, whether the funder will have any role, a consulting role, or any strict veto rights in any decisions. And then in what scenario the committed capital can be increased or decreased or withdrawn. So all these important aspects you will see in the funding agreement, and importantly, of course, how much money the funder will collect if the case is successful. These are the important aspects you can see in the funding agreement. So how is the funder's share determined? There are certain factors, but the most important 3-4 factors I put here: the amount of damages. and also importantly, the realistic amount of damages. So every client walks into your offices, they will say that they have a $1 billion case, but whether this value is a realistic calculation or exaggeration, it will depend on the assessment objective criteria of these calculations by the experts. So the funders will first look at how big your case is. And the second important thing, how long the case will take. Is it going to be a 9-month process? Is it going to be a 2 years process? From the moment they start funding until the moment they collected their money, how long they will have to wait. And this is something will affect the share amount as well. And another important factor is whether the claim settles, proceeds to the trial, or is appealed, because all this process can basically extend or shorten the process and the return time for the funders. So naturally, if the case is taking only 1 year, the funder will get a shorter amount of the money. If the case is taking too long, 5, 6, 10 years, the funder will get more share from the amount. How much is depending on your agreement, but it is generally between 20 to 40% of the amount, or multiple of what they invested. So if they invest $1 million, they can get $3 million, $4 million return, 3 times, 4 times more than what they invested. So these two type of calculation, either percentage based or multiple of their investment. These are important because another example, sometimes I want to give the numbers to just make it clear. An average investment arbitration case, depending on the claimant or respondent, between $4 to $7 million. So this is a significant amount, of course, but if you get 4 times, it is $16 million. But if the case is $1 billion case, even 10% of this case can be significant amount and significant income for the funders. So that's why the calculation, how you calculate these amounts, can be very important. So the third chapter I looked was the analysis of all the investment arbitration cases. So there are many funded arbitration cases in investment arbitration, and we know only maybe a small portion of this big area that the funded cases available to us. So in these publicly known funded cases, there were 13 different areas that the other party, not receiving not any funding, contested the funding agreement on several grounds. So I looked at how they contested the funding agreement, and I created this chapter 3 by analyzing all these cases. So these are the 13 grants that the funding agreement is contested. We don't have time, of course, to go through all of them, and not all of them are significantly important, to be honest, affecting the result. I will focus on only the contested areas and how it is affecting the practice of arbitration. One very important consideration is the security for cost. As you know, security for cost is an order at the beginning of the arbitration case or throughout the arbitration case to secure the allocation of cost at the end of the investment arbitration. So if the party, you know how arbitration, the cost allocation works, generally the winner doesn't pay for everything, and the losing party pays for all the cost of arbitration, including the cost of the claimant, the winning party as well. So if the losing party is a bankrupt company, or they don't have any money to pay the cost, this is a risk for the winning party, because even if you have an order, if the other party is bankrupt and you cannot recover anything, there is no good for you. So because of this risk, the tribunal sometimes orders security for cost, and how third-party funding arrangements are affecting the decision in security for cost applications was one important aspect. And RSM case is the first case. It really raised different ideas by different arbitrators in the panel, how third-party funding agreement should affect the security for cost decisions. In that case, the tribunal ordered security for cost, And the reason was the RSM company. They had several arbitration cases, and they did not comply with the tribunal's orders in those different investment arbitration cases. And because of this non-compliance history of the claimant, tribunal ordered the security for cost. That was the main reason. But how third-party funding should affect this decision differed between the arbitration tribunal members. The tribunal had 3 members. Dr. Griffith, one of the arbitrators, said that he had very negative opinion about the funders. He said that whenever there is a funding agreement, we should automatically default result should be ordering security for cost. Otherwise, this is gamblers' nirvana. They will just invest money without any risk. So we should always order security for cost. But the majority of the tribunal didn't agree with this decision. They said that we should only decide about the case before us. We shouldn't make a general rule. It really depends on the case. And this majority opinion was actually embodied in the new exit rules in 2022 as well. Now, as you can see, that third-party funding can be considered as a factor, but it will not be the only reason for the tribunals to make or accept or reject the security for cost application. So the second case was also Durham case and several other cases how tribunals decided about security for cost, and this was the majority opinion in other cases as well. So security for cost and third-party funding relations is important. Allocation of cost, as I said, at the end of the arbitration tribunal, one party wins, one party loses, or partial acceptance, a win-win situation. So how this cost of the arbitration will be allocated? So in all investment arbitration cases so far, the tribunal didn't take third-party funding into consideration, and they allocated the cost based on the normal principles without taking third-party funding into consideration. This is a little bit different in commercial arbitration, but in investment arbitration so far, third-party funding doesn't change the default rules about the allocation of the cost. So, due to my time, I will go a little bit faster about and share some of the empirical research of the funding market and how I conducted these interviews. I think this is important because we don't have that much empirical data on third-party funding. So actually, we need more studies. I conducted one empirical research during my PhD, but we need more actually studies because now there are even more funders operating in the market. And we need more insights about their practices. So I interviewed 26 different people from 17 different third-party funding companies, and I interviewed funding companies only who have invested in investment arbitration cases or who have considered an investment arbitration cases. So major, larger funding companies. And you can guess maybe, but I will not, of course, name any of them due to I promised them and the ethical rules of the research. But there are, at the moment, I think over 800 funders operating in the world. So it's a big portion, but not every funder is investing in investment arbitration cases. Some funders are investing only commercial arbitration cases. Some funders are investing only court litigation cases. But the funders that I interviewed was investing in or considering to invest in investment arbitration cases. So I asked them a set of questions, the same 30 questions to each one of them, and I get their opinions about these different issues raised in the investment arbitration because of the involvement of third-party funding and some of the interesting cases. I will just share a number of the funded ISDS cases because I think this is very important. I asked them how many investment arbitration cases they have funded, and I asked them how many of those cases are publicly known. And that is an interesting result because some of them say that we funded 10 cases and none of them are publicly known. And some of them say that we funded 5 cases and 4 of them are publicly known. So it really varies a lot. But as we can definitely conclude from this interview that there are much more cases funded, but we don't know publicly before until the exit disclosure rules came into place. So then we are aware of. So there are really, it's like an iceberg probably. We only see the tip, and there is much more cases in investment arbitration. Some anecdotal notes show that actually in some years, half of the investment arbitration cases were asked to get funded. But I will tell you a little bit data as well. Funders are not easily accepting cases. There are different discussions maybe related to also ethical considerations of third-party funding, whether funding is increasing the risk of frivolous claims or not, relate to ethics. And if a funder is really investing in the cases without that much merit in that case, there is a risk. But so far, I can say that from my interviews, and because of how the business works, funders are there to make money. They do a due diligence process. So it is important to explain a little bit that process as well. So a client comes to the funder's office and asks for funding, and the funder, of course, asks some questions and asks for some documents. Generally, if they have a lawyer, they have a memo, 1-2-page summary explaining the case, the main evidence in the case, how they will try to bring this case, on what grounds, what are the rules, applicable laws, and the funder looks these basic documents for it. So if they have a different policy according to the funders, but they have some red flags. If they see anything shady in this deal, in this document, anything corruption, bribery that will affect the enforcement of the arbitration award, they don't fund. So this is a very easy rejection process. In 1 to 2 weeks, they can reject the case. But if there's no red flag and they ask more questions, then they look at all the evidence they have. Maybe they ask their lawyers, independent experts, external barristers or solicitors who are expert in that subject matter of the dispute, or they are even using AI now, some funders. So they are asking, because they have huge data sets now. If a funder is in the market for 10, 15 years, 20 years, and they have been asked for, on average, let's say 400, 500 cases every year, imagine how much data set they have, and they can train AI now with the new developments as well, and they ask their artificial intelligence whether this is a good case or not. I can elaborate a little bit more how they are using AI in the Q&A session, but there are different ways of assessing cases. But what I want to give the idea is that this due diligence is a very serious process. It can take up to 6 months, or even 1 year, according to the complexity of the case. And after that, only when they are sure that they have a high chance of winning. Some funders told me at least 70% of chance, but this is not pure mathematics, right? We are social science, so how do you calculate this 70, 60%? It is always a risky part of the business, but they want the more likely to win than more likely to lose. So they invest in these cases because if they lose the case, they don't get any money, then they lose the money. And there are some funders who went to bankruptcy as well. So they wouldn't want to go bankruptcy. Of course, that's why they take this case serious. So frivolous claims argument is not that something commonly seen. I would say that as an exception. But there are, of course, some notorious cases on the market as well. Like at the moment, I should mention, since we are in Hong Kong, in Asia, that there is a very big case against Malaysia. I'm sure you have heard of it, Sulu case. So a big family in Malaysia, the Sultan of Sulu, coming from the 19th century, the Malaysia government was paying a rent since then, over 100 years, and then they stopped the payment in 2013, and then Sulu family sued Malaysia. And this case is funded by one of the major funders, and there are a lot of interesting, unique features of this case. The seat was in Spain, and then they moved to seat to Paris, and then but now even the Paris or Netherlands courts, they couldn't enforce this arbitration award, but there's a $13 billion award against Malaysia rendered by the arbitrator. So there are really important cases on the spotlight in the arbitration practice involving third-party funding. So there are different opinions about case. Actually, I will write an article about this case as well, so that's why I mentioned briefly. There are important cases going on involving third-party funding, and I like this subject a lot because there will be more cases. Whenever there is a very important case, it is highly likely that they will try to get a third-party funder on board for several reasons. They bring also expertise as well. As I said, that they are lawyers. They can be a strategic alliance. This is how funders also try to position themselves. So there are really important cases involved. But these are the important insights that I received from the funders during my interviews and afterwards. So, but I will mention a little bit other information as well. This is not even in the book actually, but I wrote this after I published the book. I started learning even more about the third-party funding. I met one of the state councils. So he didn't let me to disclose his name or country name, but he said he successfully secured third-party funding for the state he's representing on the defense side. And that was very interesting discussion for me because generally the funders are funding the claimants. However, he said that in investment contracts we have, there are also certain obligations that investors have to comply. There is a certain time limit when they need to complete building that petroleum refinery or whatever mining, they need to start operation on the certain date. And in that investment contract, if they fail to start the operation, for each day, investor has to pay a certain amount of money to the state. And what that state council told me that generally states don't follow these claims. Because for various reasons, because they have good relation or they agree on the extension, but he followed this. He said that he went to the Treasury and said that we should bring a claim against that, and Treasury said that what are the costs? And when he said that a few $1 million, they said that don't involve us, don't ask money, we will not give a few $1 million. And when he explained that if we lose, we will also pay their lawyers money, they completely backed up. And he said that, but he didn't stop there. He asked a few funders. And the funders looked at the case, and they were interested in that, and they agreed to fund the state against the investor. And then the state council, as you can see, that it takes a lot of time for him to do this, but he went again back to the Treasury, and then he said that I find a way to bring this case for free, but we need to give up certain amount of the money that we will get from the claimant. Since it was zero risk for the state, they agreed to bring the case, and they won the case. So there are actually potentials for the states to get funding as well, but not many councils are seeking this. So there's a big market at the moment operating, but there's even a bigger market that can be potentially operated. One is state funding, but second one is also the amount of the cases. So in investment arbitration, they are generally high value cases. For the investors and the funders, they are looking at different factors, as I said, realistic value. It is not a norm on the market, but general practice the funders follow. They need to get at least 10 times more than what they are investing. The funded party should get at least 10 times more than the cost of the arbitration case. So if the funder is giving $1 million, the realistic value of the case should be at least $10 million, because even if the funder gets 40%, still the majority, the big portion of the case can go to the funded party. So it will not be in something not fair deal, so it will be a fair agreement even if you use third-party funding. But because of this unwritten rule in the funding market, many cases, maybe even more, even commercial arbitration, below certain amount of money are not fundable. Even though if they are strong cases, they cannot fund because they will not get enough return from that case. That's why I'm telling there's even bigger market, potential market that can be even bigger if alternative funding arrangements can be explored by funders, by us, by you. If this is explored, there's even bigger market to be explored. And third-party funding is really interesting practice because it is also related to the access to justice argument. This is the first argument to promote third-party funding, and it is about the ethical aspect. Again, I should change my slides towards there as well. whether third-party funding is a good practice or it is a very evil practice that we should not allow. So because there are opinions differ in this area, and I told you that I will give you an answer at the end of my slides, and I will give my answer, but I will also open the discussion for the Q&A, and I would like to hear your opinions on this subject as well, or your questions if you have any. But these are the general, some main issues related to ethics of third-party funding, whether it is increasing the number of cases, frivolous cases, whether this is something that is helping to access to justice. These are the issues that are discussed. But also, just to show you different arbitration rules, we see more and more rules about third-party funding, generally about the conflict of interest and disclosure requirements, and how third-party funding future looks like. Probably we will see more and more regulations, jurisdiction-based or arbitration institutions will bring more rules on third-party funding. So, and then from there, I will just mention the best practice guideline I created in this book, and then I will give the answer to my initial research questions, and then I will end my presentation. So I created these 16 principles and explanations in the book about the third-party funders to follow so that they will not distort the practice of arbitration with their involvement, and 7 additional requirements. One thing I just want to highlight here, the motive of the funders generally is irrelevant. So they are there to make money. But if the motive is something that would affect the practice of arbitration, that can be some ethical issue for us. And I will highlight that now. We see that sovereign wealth funds in every state have huge capitals. And these sovereign wealth funds sometimes invest in third-party funding as well. So if it is a general investment, it can be. But whether is it ethical or should it be allowed a state to fund a case another state against another state? So this is some ethical issues that I brought some rules as well, whether it should be allowed or not. So these are where the money comes from, can be important in investment arbitration for this kind of practices, because in investment arbitration, this is not only private law, but there is public elements as well. Taxpayers' money are at stake. So there are important underlying reasons we should look at more closely. But this is the general area. As you see that I published on this subject extensively. I published 3 articles as well and my book, and I'm writing a few other articles on this subject as well, because the subject is developing over time. As I mentioned, that in England we have a Supreme Court case, Packard case, recently changed the whole discussion in third-party funding, and now a report work going on. By the summer this year, we will see probably new rules in England as well suggested, and will be legislation soon. So it's a developing subject. So I will just end the talk in a few minutes, so we can have time for 10-15 minutes for Q&A and discussion. So the conclusion is that third-party funding was developed in response to a need for international arbitration, and probably we will see more regulations, as I mentioned. And doctrinal and empirical analysis are important, and I put some highlights on this. And I developed this practice. Hopefully it will be referred in the arbitration cases by funders, by lawyers, or by the parties who do not receive any funding, to show that whether they are operating in a proper standard or not. So this is the goal of those guidelines. And the takeaway I want to share here, that, and my answer to my own questions, whether third-party funding is distorting the system or not, my answer is that it is not distorting, as long as the practice is not following any kind of approach that is not in the standard of the market. So majority of the funders I interacted, again, are operating in a proper way. They are lawyers. They are not doing anything shady, but as I said, that the funding market is growing. So in that sense, it is the regulation of all the sectors, right? If something is working well, we don't need regulations. Self-regulation can work. But if the market is too big to control, then it can be important to bring some standards to see that. But you need to be careful on this as well, because if you bring too much rules, it is not that flexible, you can kill the market as well. So in that sense, you need to be very careful. But my answer to my own question, that it is not distorting the system, and I hope my guidelines are bringing some standards and good practices for the market. Thank you very much for listening to me.
Thank you very much for this wonderful talk and for introducing this important and involving subject to us. So I think now we can open the floor to welcome questions. Yes.
Thank you very much, Professor. A fascinating talk, a fantastic introduction to third-party funding. And I'm very happy that you went through the history, championship and maintenance. And for a long time in Hong Kong, that's always been the biggest argument against third-party funding. So I see that it's a step-by-step process. Start with arbitration first, I think. Yeah, I'm very interested in two aspects, right? So you've got guidelines. Yeah, I mean that's from your research and all that. I'm just wondering, how do you choose those things in your guidelines? Like what criteria do you use? Why do you say this is a good guideline for third-party funding? Yeah. And my second question is something you asked yourself. How do funders use AI to choose the cases that they will fund? Thank you.
Thank you. Two great questions. Thank you for the question. What's your name, by the way?
I'm Cham.
Cham.
Yeah,
Cham. Thank you very much. Nice to meet you. And great questions. The first one, how I created the guideline. The starting point was the issues that are raised in investment arbitration cases. So I started having a rule for each issue that is raised in investment arbitration cases, because the tribunals had to look at those issues related to third-party funding. So it was the starting point. But the second thing I added to my guideline is that when... Oh, yeah, sure. Yeah. So the second thing that I had in mind was that since it was a 4 or 5 years process I was writing, I was always keeping in mind that what can be a little bit problematic in third-party funding practice. So whenever I find something that we need a rule here, I add it to my guideline. This is not definitely the only guideline or definitive guideline or conclusive list, but I feel that this is the things that I think it is important and we should have a standard, and that's why I included to the guideline, but it can be definitely developed further, and there might be even more issues that can be problematic potentially in the practice, and we can include that, but that was the standard point that is a starting point for the guidelines. I hope that answered this question. And regarding the AI, that's a very interesting subject. Not all the funders are using AI, I must say, first of all. The ones that are using AI, from the discussions that I had, they are using in this way. So they are asking the AI whether this case is likely to win or lose. And AI gives an answer, yes or no. But this is not the only decision maker in their firm. There's always human element, and then there's an expert in that subject, if commercial or investment arbitration, commercial arbitration expert or investment arbitration expert, looking at the case and the decision of the AI as well, because AI gives reasons as well. And if that lawyer thinks the same with AI, this is the final decision. But if that lawyer thinks differently, the lawyer needs to write a short report why he or she doesn't agree with AI, and then a third lawyer looks at both AI decision and the lawyer's decision, and they make a decision afterwards. So this is the method they use. So the AI is the default answer at the beginning, but the human can contest AI, and they need to give their own reasons, and that becomes the decision of the funding agreement. Thank you.
Thank you. I think we have a question over there.
Professor, at the beginning of your lecture, you mentioned about third-party funding in mediation. So I want to know about the difference when the funder assess the case. How is it different from assessment of the third-party funding in arbitration and also in mediation? How is the assessment criteria being different? And the second one is that, do you think that because I mean, in mediation, you need to be a compulsory part. Otherwise, the state or may not be so willing to participate in the mediation because of other issues, maybe transparency or confidentiality. So will the AI mediator help as well? Thank you.
Very good. Thank you very much for the question. Your name is? Grace. Grace, thank you very much. It's also important question regarding how the funders are assessing and how they are making the decision. It is not that much difference if it is mediation, arbitration, or litigation. The funder looks at the merits of the case. If the party they are funding is likely to win, regardless of the platform of the dispute resolution, and if they are likely to win, the case has merits, and then they look at whether feasible to fund. So how much money they will probably recover, how much cost will be, and then this is the decision why they need to do. For mediation aspect, I want to explore a little bit more there. Generally, mediation is not the only dispute resolution mechanism in the contract alone. It is generally integrated to the either arbitration or litigation. Because mediation, as you said, is a voluntary process. If the parties at any point walk away, there will be another process that is binding and mandatory that will compel the other party to pay or a certain amount of money with the decision of the decision maker. So in that sense, mediation will be integrated to the arbitration or litigation process. Mediation can be the final result, but if mediation fails, this case will proceed then to the courts or arbitration depending on the contractual arrangement, and the funders will look at that possibility as well. So they will look at whether there's a good chance of winning. If they think this is a good chance of winning, then they will look at the cost. What is the cost of mediation likely? How long the process? And then what is the cost of arbitration or court if the mediation fails? And after they calculate all these costs, integrated costs, if they decide that the return will be still profitable and feasible, and then they will agree to funding the mediation and arbitration. I didn't come across too much. I only came across funding of mediation cases with the interaction of the barristers or solicitors, they told me. Since I'm working on this subject, they said that I'm working a big mediation case, and then the funder is involved as well. There's a big third-party funder. So this is how I heard about these cases. But reported cases in mediation is not. Mediation is much more confidentially compared to any other process. We wouldn't hear that much. So my interactions from the lawyers that I acted in these cases or the funders, I heard these news. But generally, it needs to be big case anyway. It wouldn't be a small mediation. A rent dispute with the landlord wouldn't be funded. But I heard from some funders actually, they do sometimes pro bono funding. Actually, it is very interesting. In mainland China, there's a funder, and they told me that I can share this information as well. And they were doing pro bono funding. But they need to get the consent from their clients as well. So actually, that's why I'm telling that there's a big scope of this market that can develop further, not only for profit-based, but also how it can help to the access to justice argument as well. So there can be, but to answer your question strictly, mediation, they will look at the cost and cost of the mediation in addition to the mandatory final decision-making process like arbitration or court. And if it is feasible, they would agree.
So the mediation is just part of a supplemental process to arbitrations or other adjudicative process?
Yeah, if you look at the contracts, mediation is not, it's a voluntary process, as you said, that mediation will end as soon as one of the parties decides to leave the table. So you cannot force parties to mediate. So it can only work if the both parties agree to continue the mediation process. That's why it is not an ultimate decision making. Arbitration is not like this. Even one party walks away, there's still going to be a decision, and you can enforce that decision against that. But mediation can only work if the both parties agree to mediate and come to an agreement at the end of this process. So that's why they would look at still the merits of the case. If the case is strong, it doesn't matter for them if it goes to mediation first and then settles case there, or if it goes to the arbitration and they have to pay even more, but then they can enforce that award against the losing party. So they would look at how much costs they will have to pay on that aspect. Thank you, Grace.
Thank you. Maybe I can ask a follow-up question. Arbitration and litigation, because you mentioned that there are some like funders who fund the litigation cases. So I was wondering whether there is any significant difference in terms of the landscape of third-party funding in arbitration and in the domestic litigation.
That's a good question as well, Yue Ming. Thank you. I mean, if you ask me, actually, funding litigation cases are much more safer than funding arbitration cases. Because in litigation, at least you are in one jurisdiction. You know the rules, you know the precedents, and then you can actually estimate more likely what is going to be the result. But when we are talking about arbitration, any cross-border transaction, it has much more risks in terms of who will be the arbitrators, who will be, what will be the jurisdictions that you will try to enforce, and whether those courts will enforce that award or stop the enforcement. So there are much more risks in every cross-border transaction. So if it is only domestic matter and it is in one jurisdiction concerning only one legal system, it is much more safer because you know that legal system. You can have experts and you don't need to go abroad, another jurisdiction, and test their legal rules as well. So in that sense, it is safer. And most of the funders, I think when we have these discussions, they agree, but some funders say that, no, I only did arbitration in my career. For me, it is very easy to decide on an arbitration case, but I cannot decide on a litigation case because I never worked in the court. So it really depends on the expertise of the people who are deciding. But I agree, I don't know if it was your conclusion as well, but I agree. If you are in one jurisdiction, one court, I think it is safer. It is at least you can estimate the result much better because once you cross the border of any border, it is unknown territory, you know, like it can go anyway. Who will be your arbitrator? Whether they will be a good arbitrator looking at the merits properly or they will miss some important points. So it has much more complex risks in arbitration, I think.
Thank you so much. We have a question from Yatin.
Thanks for Professor Yue Ming to host this very interesting lecture, and thanks Professor Ken for the very insightful sharing. And before I ask my question, I want to add a small view about litigation and arbitration third-party funding. Like I know in some common law jurisdictions like UK and Australian, litigation funding is very common and the market is mature. But in mainland China is another story, like litigation funding is not allowed. Like the Shanghai court said it intervened public justice because compared to arbitration, litigation concern more with public justice and public access to judicial independence, judicial justice. So they think it's unfair for the third-party funder to intervene in this process. But in arbitration, the court said, the Beijing court, if I remember correctly, for the judgment, it said it is allowed for third-party funding. And this is the difference in China's market. And my question is, because I read your article that some mention about third-party funding in commercial arbitration. So I want to know is there are some difference in the regulatory approach in terms of third-party funding in investment treaty arbitration as well as international commercial arbitration. Because in my opinion, investment arbitration is more about public interest and states' rights. Exists some risk or more regulation in funding investment arbitration compared with purely international commercial arbitration? And another question related to this is that from your interview empirical data, when the founders, they search their funding target, they prefer international arbitration, international commercial arbitration, or they prefer international investment arbitration. Thank you so much.
Thank you. And your name?
Yating.
Yating, thank you very much, Yating. It's another good question, long question actually. I will try to answer as brief as I can, but important two questions. First, I will start from the latter, like if the funders prefer the investment arbitration or commercial arbitration. As I mentioned, that it really depends on the funders. I spoke to some funders who have really successful results investing in investment arbitration cases, and they continue investing in investment arbitration. But they also told me that there's no difference for them to invest in either commercial or investment arbitration. They look at the merits. If it is a strong chance of winning, they will invest in that case, regardless of commercial or investment arbitration, or if it is allowed, even in litigation. So, but some funders had really bad experiences in investment arbitration. They lost all the cases they funded in investment arbitration, and they are no longer investing in investment arbitration. So some of this knowledge is even publicly available, but I will not name any funder in case of a risk of breaching confidentiality. But this is the reality for them, because the things didn't go in the way that they estimated. So they lost all the cases and they lost all the money. They didn't make any profit. So that's why they are not investing anymore in investment arbitration cases. And to be honest, related to your first question as well, investment arbitration is in a very controversial situation at the moment, has a lot of problems. I mean, European Union is completely against the investment arbitration. European Court of Justice has some decisions affecting the investment arbitration as well as commercial arbitration as well. So at the moment, our arbitration is not unanimously agreed in the world that everyone thinks it is the best way of the dispute resolution. Or again, third-party funding is not unanimously agreed that it is the best method of financing cases, or we should allow that. If you look at the ancestral work, there are states discussing different aspects of investment arbitration, and third-party funding is one of them. And some states suggest that third-party funding should be banned. And there are some opinions, but this is minority. Majority of the states see the benefit of third-party funding, and they say that it should be allowed, but maybe with some disclosure rules. And it happened, it is now in the exit rules. So states are actively arguing these things. And in my opinion, third-party funding has great benefits. Whether it will increase the number of cases, it will obviously increase the number of cases. But whether it is a good thing or bad thing, I think as long as there is something wrong in a case, if an investor faced some issues and they lost their investments, and there is a legal ground to bring a case, and if there is no third-party funding, they cannot bring that case, then I think this is more problematic than having third-party funding, and that investor can bring the claim against the funder. But of course, this needs to be a meritorious claim, and that's why there needs to be some guidelines in the market as well. And European Union at the moment is working on such responsible litigation funding practices. They published such reports. So that's why I'm telling you, we will see more reports, more work, but you are right, it is not unanimously agreed that not everyone thinks that third-party funding is the best way, or even arbitration is the best way. There are a lot of problems going on, and we will see some answers from different institutions, stakeholders in the coming years as well. Thank you, Yating.
Yeah, thank you so much. I think our time is up. So I think everyone will agree with me that today's seminar is really informative and wonderful and timely. So I want everyone to join me in thanking our speaker today, as well as the wonderful questions from the audience. Thank you again.